Are you an applicant attorney or an injured worker looking to get an adequate resolution on your workers' compensation case? There's a few tools out there to help get an extraordinary award. And there's a recent case that just came down called Maria Estrella that helps provide some insight on how to do it and how not to do it. Hi, my name is Michael Burgis. I'm a legal certified specialist in California workers' compensation, and I'm a trial attorney. Before I go into the holding of Maria Estrella versus State of California, SCIF, I want to lay some foundation really quick. In California, if you're injured, the prima facie evidence of what your disability is theoretically based on this book called the AMA Guides. Now, this book basically breaks down objective factors, things like MRIs, diagnostics, correlates it with subjective complaints, and then provides you, or the doctor rather, a range that they can find for the whole person impairment. Then you rate that out, and that whole person impairment essentially becomes your permanent disability. The greater the permanent disability is, the greater your compensation is. So your compensation in California workers' compensation is based on your level of permanent disability. Now, this book, AMA Guides, is a bit conservative, and there are some times where, an injured worker has a very serious disability that's not being captured based on the strict impairment assigned under the AMA Guides. And there's been a plethora of litigation on this, and there is a binding holding referred to as Alvarez-Guzman, a few cases that were consolidated that basically said that we're not stuck to the strict impairment under the AMA Guides. Yes, that's the default, and yes, that's what everyone should do, but in rare circumstances, when the strict interpretation of the impairment is inadequate or doesn't accurately reflect the level of impairment and the impacts of the activities of daily living, it gave another tool to the physicians. They could make an analogy within the four corners of this book to another section and could argue for that impairment, and that was a huge tool. It was revolutionary. So applicant attorneys and injured workers can now actually get more impairment theoretically than the strict impairment. Well, there's been a ton of litigation on what is valid, what's not valid, what analogies work, what don't work. And the Maria Estrella case that just came out is one of those cases that really we're getting a peek at the WCAB and the insight as to what they feel is sufficient and not sufficient to effectively provide an Alvarez-Guzman impairment rating. Now, the holding in this case is nothing new, but it reiterates a point that I've stressed in almost all my videos and what I do when I litigate, and that is that it's not about somebody saying the magic words. It's not about a physician saying, yes, I think Alvarez-Guzman should apply. Yes, I think this impairment should apply. There needs to be the how and why. If there's no how and why, and it's a conclusory statement, the injured worker is not going to meet their burden, and the injured worker is not going to get that higher award. Now, there's a nuance between an agreed medical examiner and a panel qualified medical examiner, and under the Powers case, an agreed medical examiner is the court holds great deference, and it's an easier burden. But for this video, and for the most part, we're going to just talk about a panel qualified medical examiner or a treating physician, and it is the injured worker's burden to show, based on reasonable medical probability, that they've sustained injury and disability. And basically, the Alvarez-Guzman, the first analysis you have to do is the physician needs to say, here is the strict impairment under the AMA Guides. Then the record needs to be developed, and the physician needs to explain how and why that strict interpretation of the impairment under the AMA Guides is not an accurate assessment of the true level of disability and is inadequate. So there needs to be an explanation of that. And then ultimately they have to make an analogy to a different section of the guides and explain again how and why they believe that analogy is more appropriate or more accurate based on the impacts of the ADLs. And this is meant, the holding in Alvarez-Guzman, it talks about this is an extraordinary scenario. Well, the Maria Estrella case comes down, and there was a physician that did an Alvarez-Guzman analysis. Basically gave a back impairment under what's called the diagnostic range of evidence, is what the default is, and then gave another impairment on top of that under Alvarez-Guzman, and did the same with a shoulder impairment. But the holding in this case, the WCJ, the trial judge, did not give it to the injured worker. So you have undisputed medical evidence of a doctor indicating, I think higher impairment should be provided, and the court ultimately did not award it and awarded only the strict impairment. But the crux of this case is, what the board is saying is that the injured worker, the applicant, didn't sustain their burden. There was no how or why explaining this. And if you really get into the weeds here of this case, there's a lot of overlap with the doctors saying, well, this is the impairment, but then I want to tack on this under Alvarez-Guzman, but both had overlapping ratings. So really, for my viewers and my applicant attorneys or my injured workers, it's very important, if you're going to do an Alvarez-Guzman analysis, which you absolutely should on, you know these cases where the strict interpretation of the impairment is just simply inadequate, right? And you look at somebody and they're very severely disabled, and you look at what they're entitled to, and it just is absolutely grossly disproportionate. Under those type of cases, you should do an Alvarez-Guzman analysis, but you need to make sure that the physician is using the appropriate section to make an analogy, and that you are explaining how and why in each of the levels. And that is, first, they again have to explain what the strict rating would be in detail. Then they need to explain the how and why that is inaccurate or inadequate, and explain in detail. Then they have to make an analogy to a different section and explain once again the how and why that section more accurately and adequately describes the level of impairment. And then once again, I would look to make sure that there's no overlap. That is, that if they're adding any rating, that they're not getting duplicative impairment. And this one, for instance, the low back, it was indicating loss of muscle strength, and then they added another impairment that also dealt with loss of muscle strength. And basically that's a period of duplication and overlap. So very, very complicated, but the holding can really be summarized as, under Maria Estrella, there needs to be the how and why. It's the applicant's burden, and if they don't explain how and why, they're not going to sustain their burden. But it's a great peek into the WCAB's decision process and what they're looking for, which frankly is nothing new. I've been arguing this from day one, but again, it's a good reminder. So if you're an injured worker and you believe the impairment you're getting under the strict impairment isn't adequate or accurate, and you believe Alvarez-Guzman would be a good effective tool, this is a good roadmap for you to make sure that you dot your I's and cross your T's, and you really explain the how and why. So the how and why is absolutely important. Conclusory statements will not be upheld. If you have any questions or concerns and want to go over the specific facts of your case, honestly, we're here standing by. I like to help out everybody. If you have questions, we have the answers, and we're here to help. Did you like this video? You may find these videos to be helpful as well. Please click the links below.